Niko Resources Limited versus the People's Republic of Bangladesh and Petrobangla. Niko Resources Limited is a Canadian oil and gas company that operated in Feni gas field in Bangladesh, a field under management of the state-owned Petrobangla. In 2005, a catastrophic blowout occurred in Feni gas field, resulting in significant environmental damage including contamination of nearby water sources and soil as well as the considerable economic losses. The blowout led to the halt in gas production, impacting Bangladesh's energy supply, causing a severe disruption to its economy. Following the blowout, the government of Bangladesh and Petrobangla filed claim against Niko Resources, asserting the company's failure adhered to industry safety protocols and the production sharing contract led directly to the incident. They sought compensation for both environmental restoration and the financial losses caused by the prolonged suspension of gas production. Niko contested the claims, arguing that the blowout was an unforeseeable event and it had taken a reasonable safety precaution in compliance with industry standards. Additionally, Niko raised objection to the tribunal jurisdiction, claimed that the arbitration clause in PSC did not apply to the case in hand.
All rise. The arbitration tribunal is in now session. Please be seated. The case before the arbitrations, the People's Republic of Bangladesh versus Niko Resources Limited Company. May I request learned counsel to give their submission?
Honorable arbitrators, I represent the People's Republic of Bangladesh and Petrobangla in this arbitration concerning the blowout at the Feni gas field operated by the Niko Resources. The incident caused by Niko's negligence resulted in severe environmental damages and substantial economic losses. First, Niko clearly breached its obligation under the production sharing contract. The contract requires Niko to operate safely, follow stringent environmental damage standards, and manage risks appropriately. However, Niko failed to maintain essential safety protocols, leading directly to the blowout. Their delayed responses further exacerbated the environmental damage, which was avoidable had they adhered to industry-based practices. Second, the environmental damage caused by the blowout was devastating. Not only did it harm local ecosystem, but it also disrupted the gas production critical to Bangladesh energy sector. Niko, as the operator, is responsible for this damage. The government and Petrobangla had to bear significant costs to repair the environment and address the consequences of this disaster. But the economic impact of the blowout is undeniable. The halt in gas production led to immediate and long-term financial losses for Bangladesh. As energy supply was disrupted, Niko must compensate for both the environmental remediation cost and the lost revenue from the field. Finally, Niko's objections to the tribunal's jurisdiction are without merit. The arbitration clause in the PSC is clear, and both parties agreed to resolve dispute through this process. In conclusion, we request that the tribunal find Niko liable for all damages, including environmental remediation, lost revenue, and economic harm. We seek a full and fair compensation for the losses suffered by Bangladesh and Petrobangla. Thank you.
May I request the defense counsel to give their submission?
Honorable arbitrators, I stand before you today representing Niko Resources Limited, and we respectfully submit that the claims made by the government of Bangladesh and Petrobangla are not supported by the facts or the terms of the production sharing contracts PSC. And I am going to just fix the three standing points from my defense position. The economic losses claimed by the government are inflated, and the gas fields production loss was temporary, and the economic damage claimed does not reflect the actual long-term impact. Any claim of financial term and should have been sustained with the concrete evidence, and we submit that each evidence has not been adequately provided. And we submit that such evidence has not been adequately provided. Finally, regarding the jurisdiction of this tribunal, Niko acknowledges the arbitration clause in the PSC, but asserts that the claim brought against it are excessive and unjustified. We respectfully ask the tribunal to consider these factors and find that Niko should not be held fully responsible for the damages are claimed. We respectfully ask the tribunal to consider these factors and find that Niko should not be held fully responsible for the damages claimed. Thank you, and the defense rests.
Finally, the Petrobangla has enough evidence to establish the prosecution's argument.
Third, any claim of financial harm should be sustained with concrete evidence, and we submit that such evidence has not been adequately provided.
Good morning, esteemed members of tribunal and all parties involved. Today we address a significant dispute between the Niko Resources Limited and the government of Bangladesh, along with Petrobangla arising from the blowout at the Feni gas field. Upon reviewing the evidence, it is clear that the blowout was a catastrophic event with significant environmental consequences. As the operator of Feni gas field, Niko Resources was responsible for adhering to safety protocols and risk mitigation strategies. The evidence suggests that Niko failed to implement adequate safety measures contributed directly to the blowout, and the negligence constitutes a breach of its obligations under the production sharing contract. Niko failure to meet the required industry standards of care is a violation of PSC.
Furthermore, the breach contract Niko significantly contributed to both environmental and financial damages by claim by the government of Bangladesh and Petrobangla. The BSc clearly mandates Niko to uphold high standard of safety, which is failed to do, leading to the damage caused by blowout. On the issue of compensation, it is clear that the Niko liable for the fully extent the environmental remediation cost and the lost revenues resulting from disruption of gas production. The cost of cleanup, restoration, economic losses, and must all be considered as the final compensation. Lastly, regarding the jurisdiction, the arbitration clause within the PSC binding, Niko's objections are without merit. This tribunal has fully authority to hear resolve the dispute. Therefore, based on the evidence, I conclude that Niko Resources liable for the breach of contract environmental damage. The tribunal will proceed to determine the appropriate compensation of the government of Bangladesh and Petrobangla.
Thank you, Chairman. This case involves serious environmental damage and breach of contract by Niko Resources. My focus will be on the legal and factual aspect, including Niko's liability for the blowout and its failure to meet PSC obligations. On environmental damage, I agree with the Chairman that Niko's failure to follow safety protocols directly contribute to the blowout. While there is a shared responsibility, Niko's actions are a key factor, making them liable for environmental damage. On breach of contract, the PSC clearly requires to ensure operational safety. Their failure to prevent blowout constitute a breach of contract, and I fully support the Chairman's findings in this regard. Thank you.
Thank you, Chairman. I will focus on the legal and factual issues related to environmental damage and breach of contract, aligning with the Chairman's findings, but also considering regulatory oversight. I agree that Niko is liable, but we must also recognize the regulatory role of Petrobangla. However, Niko's failure to comply with industry standards and mitigate the damage was critical, and they should bear responsibility for the environmental harm. Niko's failure to ensure safety at the ferry field breaches the PCS terms. I concur with the Chairman's assessment of Niko's responsibility in this matter. Compensation should address both immediate and long-term financial losses. I agree with the Chairman's general approach, but emphasizes considering future impacts on production and revenues.
Thank you, Chairman. I will address jurisdiction and reinforce the findings on compensation. And I support the Chairman's rulings that this tribunal has full jurisdiction. Based on clear arbitration clause in the PSC, Niko's objections are without merit and we are authorized to proceed. Then on compensation, I agree that compensation must cover environmental and financial losses. Additionally, we must factor in future revenue losses and long-term economic impacts. I support the Chairman's overall approach but emphasize long-term considerations. Thank you.